back to winning isn't easy. What happens when the workers' compensation records are considered in an ERISA disability claim, but a TPA or carrier like Sedgwick selectively removes portions of the workers' comp records from the file to deny or terminate benefits? Now, are you surprised? Many claims for ERISA disability benefits can arise out of a workers' compensation claim. And the question becomes, should your workers' compensation records be part of your ERISA disability carrier's file? Now, this is a hard question to answer. I am also, in addition to being an ERISA disability attorney, Social Security attorney, a workers' comp attorney. And I know, based on my years of experience doing both claimant and defense work, that work comp doctors are not supportive of a workers' comp claim. Having defended many workers' comp claims, I know that defense doctors know where their bread is buttered, if you will. They know who pays. They know who is going to be sending them a stream of clients. They know that their income depends on doing basically what the work comp carrier wants them to do. Now, if the work comp doctor is supportive, then certainly we want those records to be part of the long-term claim. But the general principle is that the disability carrier is going to obtain the workers' comp records, and they're going to consider those in making a claim determination, and they may even selectively remove portions of the records when they produce your claims file to us in the course of ERISA litigation. If you don't think that happens, you're wrong, and hiding things and removing things in a claim file is common practice. Now, under ERISA regulations, the administrative record is to be produced in litigation, and the court reviews what was considered, all of the documents, the records, other information, the Social Security file, the medical records. In fact, under ERISA regulations, documents, records, and other information that were relied upon in making the benefit determination were submitted, considered, or generated in the course of making a benefit determination without regard to whether the document, record, or other information was relied on, needs to be produced. And there has to be a demonstration of compliance with administrative processes and safeguards required by ERISA. So that's the starting framework. But how does this work in reality? So again, let's talk about the Chaco case, Chaco versus AT&T. Chaco was a software engineer who began working for AT&T in 1997. 20 years later, began to develop problems with her neck, her shoulders, and both of her arms, with tingling and numbness. Sedgwick claims management services just so happened to be the servicing agent for their workers' compensation claims and their short and long-term disability claim. Now, Sedgwick paid her short-term disability benefits, and after several months of paying her long-term disability benefits, denied the claim on the basis that the medical evidence did not support ongoing disability. Well, guess who tried to hide the ball when the case ended up in litigation? Sedgwick Claims Management Services. They had the workers' compensation file in its possession when it decided the long-term benefits, and it explicitly relied on certain parts of the workers' comp file when it denied her claim. When Sedgwick produced her claims file in litigation, they didn't include 147 pages of records from the workers' comp file, which included medical records in the form of progress reports and work status reports. Well, how did Chaco know that Sedgwick was hiding the records and took the records out? Well, Sedgwick sent her medical records to a peer review doctor who summarized all the missing records in this part of his report. Obviously, Chaco wanted the federal judge to review all those records as part of the lawsuit and filed a motion with the court saying, look, the records should be supplemented with these records that they removed. And guess who objected? Not only didn't they want the judge to review the records, they didn't even want them to consider them. As I said, Sedgwick was the workers' comp carrier for the employer, and the work comp progress reports were sent to Sedgwick as the workers' comp administrator. It had Chaco's workers' compensation file in its possession, and in fact, used it in denying the claim. Didn't necessarily directly quote it. That would have given up the game that they had the file. It was only, again, through the peer review doctor that they all found out and I was not involved in this case, about the workers' comp file. Now, the judge was not impressed, particularly since the peer review doctor reviewed and considered these reports in preparing his report that Sedgwick relied on in denying her long-term claim. The judge granted Chaco's request to expand the record to receive the workers' comp records. So if you suspect that your ERISA disability carrier or the plan administrator is hiding the ball, it's time for you to consult with an experienced ERISA disability attorney, because all relevant material evidence needs to be submitted as part of an appeal. And if the denial is upheld, then you certainly do need to hire an experienced ERISA disability attorney, because you'll have the need to file a lawsuit in federal court. And as I've said, as part of the lawsuit, they have to produce the claim. Now, the claims file. They also have to produce the claims file during the appeal process. And I will tell you, I often look at that claims file that they produced during the appeal and the claims file they produce in litigation. Do you think that they're the same thing? No. Another fertile ground for arguing that a denial or termination was inappropriate. I hope you've enjoyed this week's episode of Winning Isn't Easy. Please like this page, leave a review, share it with your family or friends. Subscribe to this podcast, and that way you'll know when an episode comes out. Please tune in next week for another insightful episode of Winning Isn't Easy.